All right, guys. This is Professor KACHALIA, and welcome to our episode number 9, where we are going to discuss MCQ number 71 to 75. So, again, we are continuing with the same trend of 10, 10, 5, 10, 10, 5, and here comes your 10, 10, and another 5. That is your 71 to 75. All right. These 5 MCQs, again, you can when you see the MCQs, when you read them, you will understand that, okay, the level has gone a little bit higher. The bar has been raised a little bit higher, and it will only demand a little bit of more conceptual clarity from you. Let's figure it out. Let's see the questions. Let's try to answer the answers. Yes, let's try to find out the answers, and let's try to understand instead of mugging them up. Am I right? All right. So bringing up question number 71 on your screen right now. 71 comes up saying Mannat Company LLC, who is a company incorporated outside India. It proposes to establish a place of business in India through electronic mode. It is proposing. Okay. It is proposing, not yet. Okay. This company has issued a prospectus to the citizens of India for subscription to the Mannat Company securities. Are you serious, Mannat? Yes. You don't even have a place of business in India and you want to offer shares to the citizen of India. Mannat LLC has been in the business for more than 2 years since the company received a commencement of business certificate. Okay. The prospectus was duly dated, duly signed, but it did not contain any particulars relating to any enactments under which Mannat Company was incorporated. It does not have any details relating to any establishment in India. You, as a pursuing chartered accountant, you are required to examine the validity of the prospectus. Well, when I read the third last line, automatically I will know the answer. Automatically you will know they are trying to put it in your head that the answer is, why should I tell you? Yes, 30 seconds. You think it out. All right, guys. Come on. So, now tell me, the answer is prospectus cannot be issued. It is invalid as per the law because details required, particulars required. See, I have told this to you in my class also. Do anything you want, but do not mess with SEBI regulations. When you are issuing a prospectus, SEBI regulations will come into picture. And plus, when the question is, what if you are not an Indian company, you are a foreign company, SEBI regulations will be even more strict. You need to be even more alert, more on your toes. So think wise, think twice, and then give me the answer, which is D, that it is absolutely invalid in the eyes of the law. All right. Question 72 coming up on the screen. Akar Solar Energy Private Limited was allowed the status of dormant company. Okay, they have been allowed the status of dormant company. Certificate has been given to them with effect from 1st July 2018. Now this question over here is about, once you have obtained the status of a dormant company, for how long you can stay dormant? Is it like you obtain the status of a dormant company and then sleep in peace and I don't want to do any business for the rest of my life kind of an attitude which will work? Yes, no, tell me. Of course not. I mean, of course not. It shouldn't be like that, right? Otherwise, I will incorporate 10 companies and take 10 certificate of dormancies and then leave them. No operations, just dummies. Should it be allowed? So here, they are asking you, if at all, the name of such company has to be struck off from the register. It can be done after how much period? From which date? 4 options are there on the screen. Refer 248 to 252. See if you get an answer. I'm confusing you. Plus, refer section 455 with its rules and tell me if you don't find your answer. Enough hints given. Time starts now. Hands up, hands up, hands up, hands up, hands up. Tell me. So, what's the correct answer? Yes, it is 5 years, as you know that. 30th June 2023 is the day. All right. I hope you found the provision and I hope you found the answer as well. Going to question 73 very swiftly. Let's see. Nanny Marcons Private Limited, who was incorporated on 9th of June 2017. For the financial year 17-18, it did not file the financial statements or annual return. Point to be noted, 17-18, annual accounts, financial returns, not filed. Okay. For the timing, the company desires to be treated as an inactive company. I don't care whatever you want to be treated, you should at least file the statements, right? Okay. Since it does not carry on any active business with this permitted by its memorandum, so it wants to be treated as an inactive company. Okay. As to when the ROC can issue the certificate of status of a dormant company to Nanny Marcons on the basis of non-submission of the financial statements, if the company makes the application to the registrar in this respect. So when can this certificate of dormancy can be issued to this Nanny Marcons Private Limited? Straightforward question from 455. If you understand 455, yes, it's an entire section on dormant companies. Read through that, read through the provisions, and then tell me the answer. Your time starts now. All right. Kiddos. So the answer is B. That is after the non-submission of the financial statement for the next financial year also. That is 17-18 already not submitted. 18-19 also is not submitted. They will receive a certificate of dormancy where they will prove that they are anyways not into any active business. That clear? Yes? All right. Let's go to question 74. Mr. Rudra. An employee of the company has filed a complaint against the company for illegal issue and transfer of securities before the special court. Whoa, chapter change. State the correct basis for the rejection of the said complaint. So Mr. Rudra, who is an employee, has filed a complaint in the special court about illegal issue and transfer of securities by the company. I'll give you a hint. Direct section is there in company. Direct section is there. Straightforward answer is there. We will discuss after 30 seconds. All yours. Done. Yes or no? Clear? Did you find the answer? Yes. The answer is employee is not competent. Employee is not a competent person to file a complaint against the company for the offense regarding issue and transfer of securities. You are a member, you are a shareholder, you are a person with whom the company has done any kind of a cheating or a fraud, and you are filing a complaint. We can understand. Yes, we can do it. But the court says, employee, you might be taking a revenge. Sorry, you are not a competent person to file such kind of complaints. Yes, 75. On the screen, here you are. Quite a question it looks. Let's analyze it. Let's understand it slowly. Mr. A, B, C, D, E are the directors of Elite Limited. The board of directors of Elite Limited conducted 5 board meetings. Okay. In the year 1920, there were 5 board meetings wherein A, C, D attended all the board meetings. B has attended 4 out of the 5 meetings, whereas E has failed to attend all the meetings. E, who failed to attend all the meetings, has not vacated the office of the director of Elite Limited. You are required to choose the correct option as to the consequences of Mr. E. That is, what will Mr. E be liable for? First option is Mr. E shall be punishable with imprisonment up to 1 year or with fine 1 lakh to 5 lakh or both. Second, Mr. E shall be punishable with imprisonment up to 1 year or minimum fine of 25,000 to maximum 5 lakhs. Third, punishable with trial if the special court thinks it fit that we should go for a summary trial in this case. Fourth, Mr. E is punishable with imprisonment of 1 year. That's it. Choose the correct option. A, B, C, D. Yes. The question is all yours. 167 mixed with special courts. Chapter. Interesting question. 30 seconds. That's enough. Time is up. Time is up. Time is up. What's your answer? Did you find the answer? Honestly, tell me. This was a very, very interesting CA final level of a question where 2 different chapters were combined to ask this question. Yes, the answer was 1 and 3. Now, how 1 and 3? Let's see 1. He shall be punishable with imprisonment up to 1 year, fine 1 lakh to 5 lakh or both. Straightforward question from section 167, vacation of office, direct penalty given to you. So, no confusion over there. Though many of you might have selected A as one option. Correct? Your answer is wrong. Of course, by now you have known that. 3 says he shall be punishable with a trial if a special court allows summary trial. What is summary trial? If you have known, we have a short note given in our summary notes also for summary trial, explaining the concept of summary trial. That is, summary trial is a trial where the offense has been committed and the penalty in the law for such kind of an offense is not more than imprisonment of 3 years. And the punishment which can be given for such kind of offense cannot be more than imprisonment of 1 year. So as per the law, penalty imprisonment should be not more than 3 years. Then the case qualifies to come for summary trial, and the punishment given in this case should not anyways not be more than 1 year of imprisonment. Maximum 1 year imprisonment can be given. Then it is considered to be a case qualified for a summary trial. You see the penalty if you have selected option A, that is option number 1. Imprisonment is any which ways not more than what? 1 year. So the case very well qualifies for a summary trial, right? Yes or no? So in that case, 1 and 3, that is option number B, was your answer. I hope most of you might have got this answer correct. I hope so, but I'm not very sure that you might have got this one correct. But this is where you need to understand the level of questions that are going to come for you. So the level of conceptual clarity that is required for you. Summary notes, make them, make of your own. If you have, great. If you don't have, call me. Main book, you have your own, very good. You are referring any author, very good. If you don't have, call me. Scanner, that is a practice question answers, practice manual or a question bank. If you have of your own, great. But if you don't, call me. Anything you require, please get in touch. Video lectures also you want, please get in touch. Anything you want, please get in touch. Results this time were average overall, but I am super proud today to tell you that we have got fantastically phenomenal results. A lot of exemptions in the law paper. Yes, almost everybody has passed. Almost everybody has passed at least, because summary book only if you read 10 times, 40 is like very easy for you to score there. My aim is 60 or above. When you are taking a class with me or referring to my main book or question bank or summary notes, targets have to be higher, right? So any which ways, I hope you have it all, and I'm sure you might have planned your studies well, but in case anything is lacking, get in touch with me. Yes, always there to help you. Winding up this particular episode, number 9 over here, Professor Harsh Kachalia signing off, always praying for your good health and well-being. Thank you very much. God bless you all. Thank you.